The record in the matter of the people of the city of Lansing versus Dominic Salazar, file number 23-00201. Council parents.
Assistant Public Defender John Lee, appearing on behalf of Dominic Salazar.
Mr. Vinker, are you there?
Hello, is my mic on?
Excuse me?
Oh, I'm sorry. I was just making sure my phone was unmuted.
Yes, we're waiting for the city attorney.
Oh, okay. I'm sorry. I just was making sure that you guys could hear me and everything was working properly. Thank you. Hey, turn that down, please. Turn that down.
Mr. Vinker, can you hear us?
Sorry, Judge.
Okay, have your appearance for the record.
What matter is being called? Is this Salazar?
Yes,
City appears by Greg Venker.
okay. Today was the date that was set for a hearing. I ordered the defendant to appear in person. Mr. Salazar, why are you not present in person?
A few days ago, my son came home sick. I took him to the hospital, and he tested positive for influenza A and COVID. And in the last couple of days, taking care of him, I became positive for COVID.
We'll reset your matter.
I didn't want to not appear at all, so I made sure I got on here and typed in your ID so I could be there. You know, not there, but
March 18th at 1:15 in person at the court.
okay. Thank you, Your Honor.
You're all set for today.
All right, I'll see you guys then. Have a great day.
Thank you. Let's see, on the record in the matter of the people of the city of Lansing versus Lamar Douglas, file number 21-01320. Council appearance.
Good afternoon, Your Honor. City of Lansing appears by Greg Venker.
Assistant Public Defender John Lee appearing on behalf of Lamar Douglas, who is in the courtroom and standing tonight.
Okay, today was the date and the time that was set for a hearing on probation violations that you were arraigned on back on February 12th. And that was for failure to report in January 2024. And then for failure to do random testing, December 9th, December 28th, January 1st, January 8th, January 18th, January 21st, and then also failure to provide verification of the 12-step program. And then it looks like I have additional no-show testing. One is for January 29th, one is for February 5th. So you have the right to have a contested hearing today. How are we proceeding, counsel?
Your Honor, Mr. Douglas is admitting to it.
That's all of the violations.
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yeah.
Thank you. Put your hand down. So you understand, sir, that you do have the right to have a contested hearing on these violations?
Yeah.
You understand that you have the right to have the city attorney's office in conjunction with the probation department put forth evidence to support the allegation that you have violated your probation terms as they have alleged in the complaint.
Yeah.
You understand that if you're found to be in violation of your probation status, your probation can be terminated, it can be continued, or it can be extended. I can also impose jail time or other additional oversight as a part of the violation. You understand that?
Yeah.
You want to waive your hearing and plead guilty to the violations?
Yeah.
Anybody threatening you to do that?
No.
Any promises being made to you in exchange for you entering a guilty plea to the violation?
No.
As to the violations that you failed to report to probation January 2024, how do you plead?
Guilty.
As to the violation that you failed to do random testing on December 9th, December 28th, January 5th, January 8th, January 18th, January 21st, January 29th, and February 5th, 2024, how do you plead?
Guilty.
And the violation that you failed to provide verification of 12-step attendance, how do you plead?
Guilty.
Factual basis, counsel.
Thank you, Your Honor. Mr. Douglas, is it true that you were convicted in the 54A District Court for the misdemeanor crime of operating while intoxicated first? Yes. And as a result of that plea, you were sentenced to a term of probation, correct? Yes. And as part of that probation, you were ordered to report to your probation officer, correct? Yes. You were also ordered to undergo random testing, yes? Yes. And you were ordered to attend 12-step and provide verification of that attendance to your probation officer.
Yes,
And did you in fact have an appointment to visit with your probation officer on January 20th? I'm sorry, was it January 20th or January 19th? January 19th, I apologize. Did you have an appointment? Yes. And did you fail to keep that appointment?
yes,
And you had some random testing that was also assigned specifically December, that was ordered rather, specifically December 9th, December 28th of 2023. Did you fail to appear for random testing on those dates?
yes,
January 5th, January 8th, January 18th, January 21st, January 29th, and February 5th of 2020. Have you provided any documentation to your probation officer in regard to your 12-step meetings?
no, I tried to go report last week, but she said I had to come take care of this matter first.
Okay, so as of right now, she has not received any documents. Okay, thank you. No further questions.
Any questions from the city?
None, thank you.
Court satisfied with the factual basis, I'll accept your plea and find it to be freely, voluntarily, and intelligently made. A recommendation from the probation department is to extend the probation. It says defendant was allowed to pay clearance fees first so he could get a license to move, to make testing. Defendant was advised to provide work schedule so that they could adjust his testing times. He never provided it, they stated. It says the first test was a Sunday, not working still, and defendant was not working, I guess is what that's trying to communicate. And defendant still did not test, showing very little effort and no communication. You can address the court.
There are two main underlying issues for Mr. Douglas. One is transportation and two is health. He has a job that does require him to work frequently and start early in the morning. But he has no transportation, so he has to take a bus to and from work, and he has to be there by a certain time in order to get on a company van to go to whatever store they're doing the inventories at that day. So he has some challenges with reporting, although has intimated to me that he believes he can report for testing in the afternoons. And intends to and wants to make that a priority and get that worked out because he understands it's a necessity of his probation. In regard to reporting to his probation officer, there was a lot of things going on that week. They were originally supposed to meet on the 17th and his car broke down Thursday. He thought maybe he could appear by Zoom, but she wasn't doing Zoom meetings. So on Friday, he was supposed to go meet with her. I'm not sure what time their appointment was scheduled or whatever. He did end up going to the hospital Friday night and was admitted to the hospital the next day on the 20th. We have documentation to that effect, Your Honor. Does your court like to have this? Okay. So, you know, he's been dealing with some health issues and his work schedule perhaps has exacerbated that some. He does also report that he's been attending 12-step meetings, but has not been able to get the documentation to his probation officer, which again, we have spoke. He understands that's a priority. It's not, it's like not going at all when she doesn't see any documentation. So that's the situation, Your Honor, and we're asking the court to take that into consideration in assessing your sentence. Yes, yes. And yes, yes, and to add to that allocution, Your Honor, he has paid his fines, he has attended his class, he has been doing a lot of other good things on his probation, including primarily his work and his job. So, okay.
You saying that you completed the victim impacts that we were talking about?
Mm-hmm.
Is that a yes?
Yes,
Okay, well, this is the concern. The court ordered you to participate in testing. You're before the court for an alcohol-related offense where your blood alcohol was above a 0.30, 0.345 actually, to be exact. It's extremely high. And in the last 3 months, you've not consistently tested when ordered. Recognize that there were some issues that may have cause testing to be more difficult. Uh, But you agreed to be on probation, understanding that you have those limitations as it relates to your license. Did you get your license reinstated?
Yeah, I got a license, but I don't have a car to drive.
Okay.
I'm not driving.
And so the primary concern for the court is to make sure we're not missing an opportunity for further counseling or treatment as it relates to the substance abuse or substance use. And we can't do that if you won't appear for your random testing. And as stated by your attorney, if you attend 12-step as ordered but don't provide verification, not only is it not like you didn't attend, my order specifically says to attend with verification. I could care less if you're attending if I don't know about it. And it doesn't take much for you to provide verification to your probation officer. So that's something that you easily could have done. You don't have to have a vehicle to do it. It doesn't matter what time of day you send it to them. You just need to get it to them, and you've not done that. So I do have a concern. The recommendation is to extend it 2 months. I'm going to extend it 3 months because you haven't tested in the last 3 months. So I'm extending your probation for 3 months, and I'm adding a sober link for the next 3 months. That way I can test you wherever you are. So you'll get sober link added immediately. When you leave here, you'll go downstairs and meet with your probation officer, find out what you need to do to get the sober link added. Do you have any questions today?
No,
You also should make sure you provide verification that you've been attending the 12-step meeting as ordered to avoid any further violations relative to that issue. Any additional matters for the record?
Not for the city.
Nothing for the defense, thank you.
You're all set. We'll get you downstairs to probation. Okay, I think that's all I have for the city, correct? Okay. Thank you, Mr. Vinker.
Thank you, Judge. Sorry again.
No worries. Ms. Serby, my apologies if I didn't say that right.
You said it correctly.
Okay. Have you had a chance to speak with Mr. Kelly?
No, we have not had a breakout room yet.
Okay, well, okay, so have you, do you have the civil pretrial statement? I can email that to you so you guys can do that while in the breakout room.
Okay, if you want to email that to me, I'm not pulling it up right now. Oh, no, I don't have it. Are you able to email it?
Yes, if you want to just send me a chat with your email address, just so you don't have to
Sure.
give it over the live internet.
Okay, sent.
Let me know when you receive my email and then I'll put you two in a private breakout room.
Okay. Okay, I received the email.
Oh, Jesus.
Ms. Serby, are you all set with Mr. Kelly?
Yes, I am.
Okay, were you guys able to complete a joint pretrial statement?
Pretty well. We just we had talked about wanting to open up discovery for a period of about 60 days if possible to get to the bottom of some of Mr. Kelly's complaints and his answer. I don't think a trial will be necessary at this point. So just I think looking for discovery in the next 60 days.
Okay, I will let the judge know, and then you're also here for the matter with Miss Hill, right?
Yes, I am.
Okay, so I will put you two in a private breakout room.
Okay. Thank you very much. Ms. Hill and I have had an opportunity to speak as well, if we're able to talk about that.
I will let the judge know.
Okay.
People didn't show up. Let me see. I see. Attorney Beers, which matter are you here on?
Oh, yes, Your Honor, here for plaintiff on Capital One versus Jessica Hatch.
Okay, that's file number 23-02653. And today was the date that was set for a pretrial. No parties appeared on behalf of Mixed Patch. Let's see here. We do not have a judge in this case. Okay, looks like I set this matter for a pretrial because my understanding is that there should have been a settlement or a consent judgment that was faxed, but our civil department indicated that nothing was ever received.
That is correct, Your Honor. We prepared a consent judgment and faxed it to the debt settlement company, National Debt Relief, on January 3rd with instructions to please sign and send back. They never signed it and they never returned it. We followed up a couple of times. We never heard back from the debt settlement company or the defendant.
Okay, how would you like to proceed?
Plaintiff moves for entry of default judgment, the amount of $4,019.77, which is composed of damages of $3,896.81, court filing fee of $75, service fee of $47.96, for a total amount of $4,019.77, minus a payment of $552, which we received on January 11th of 2024, minus another payment of $552, which we received on February 15th, 2024, for a remaining judgment balance due of $2,915.77.
Okay, default judgment will be granted and you can submit that paperwork through my file.
I will do so. Thank you, Your
Any
Honor.
additional, do any other matters today?
No other matters, Your Honor.
Thank you.
Thank you, and have a good day.
Thank you. Okay, Attorney Servi, which matter are you here for?
Hi, Judge. I'm here for LVNV funding versus Miguel Kelly, as well as LVNV funding versus Annette Hill, plaintiff's attorney for both.
Okay, LVMV funding versus Miguel Kelly, the file number is 23-02716GC, and Mr. Kelly is present. Did you all complete your joint pretrial statement or come to a resolution?
I think at this time we had an opportunity to speak. We would like to open up discovery if possible for 60 days.
No, you need to complete a joint pretrial statement and then we'll address that. Did you complete the joint pretrial statement? It should address that on your joint pretrial statement.
We basically talked about everything that's on here, but we didn't get anything in writing, so I can just draft that up and then submit it if that's acceptable.
Do you have a copy of the court's joint pretrial form?
Yes, it was emailed to me.
Okay, that that needs to be completed. You'll sign it, you'll get his permission to sign, and then you can file that with the court.
Okay,
And you put your discovery period or how much time you need discovery on that form.
okay, thanks.
No problem. Do you need to go back in the breakout room right now to do that?
Yes, please.
You're already in room 2, so return to room. Actually, let me move you and you'll get a new notification.
Okay, thank you very much.
Oh, sorry. Let's see. Miguel, let me move him to room 3. Okay, and I see Attorney Bankstein. Looks like Annette Hill left. And then she's in the breakout room. Oh, okay, I'm not sure why. And then Michael Bankstein's not responding. Okay, Council Servi, are you and Mr. Kelly all set on the joint pretrial statement?
Yep.
Yes, Judge, we are.
Okay, and Mr. Kelly, did you have any questions about that?
Nope.
Okay, and did you give Ms. Servi permission to sign that statement on your behalf?
Yes.
Okay, once I receive it, I will review it and sign, and that is what we will use to create your scheduling order, so you'll know what your deadline is for discovery, your deadline to file any motions post-discovery, and then your deadline or your dates for your trial will come from that as well, okay?
Okay.
Okay, any additional matters, counsel, on that file?
No, Judge.
Okay, you're all set, Mr. Kelly, thank you.
All right. Thank you, Judge.
You're welcome. Okay, on the record in the matter of LVNV Funding LLC versus Annette Hill, and this is file number 23-06226. Counsel, your appearance on this file.
Francesca Servi, attorney for plaintiff, bar number is P87205.
Okay, Ms. Hill, did we lose you?
I'm present.
Okay. Very good. Okay, and you already met with Ms. Serby, Ms. Hill?
Yes.
Okay, council, did you all complete a joint pretrial statement, or do you need to go in the private meeting room again?
We'll need to go in the private meeting room again, please.
Okay, I am going to move you to room 1.
Okay, thank you.
You're welcome. And then Attorney Bernstein, can you hear me now?
I can. I could hear you. It's for some reason my microphone button was frozen. I kept clicking it and it wouldn't do anything. So I switched devices and now it's working. Apologize for that slight delay.
No problem. Okay, let's see. You must be here on my last remaining matter. Absolute resolutions versus Christopher Armstrong, file number 23-02915 GC. Appearance, please.
Good afternoon, Your Honor. Michael Bankstein, P 69778 on behalf of Absolute Resolutions Investments.
Okay, and today was the date set for a pretrial and a general civil proceeding. No one has appeared on behalf of Christopher Armstrong. This matter was set for 2:30. It's currently 3:07. How did you want to proceed, counsel?
I'd like to move for a default judgment, Your Honor.
Default judgment will be granted. You can file that judgment on my file.
Thank you. And I'd just like to put the numbers on the record. Damages in the amount of $6,188.99. Cost in the amount of $127.08, plus the statutory fee of $75 for a total of $6,391.07, Your Honor.
Very good. That's noted on the record. Any additional matters for today, counsel?
I have nothing further, Your Honor.
Thank you. Have a good one.
Thank you. You as well.
Bye. Okay, back on the record in the matter of LVNV funding versus the Net Hill. Council, did you all come to a resolution or a joint pre-trial statement?
We had a joint pretrial statement.
Okay, that's correct, Ms. Hill.
Yes.
Did you have any questions about the joint pre-trial statement?
No, I don't.
Okay, and did you give Ms. Serby permission to file that, sign that statement and file it on your behalf?
Yes.
Okay, Ms. Serby, you can submit that on my file, and then we'll get a scheduling order sent out based on that, okay?
Okay, thank you very much.
No problem. Any additional matters for today's record?
No, Judge.
Thank you. You're both all set for today.
Thank you.
Thank you.